All right. Hello, everyone. Hello, hello. We are going to get started in just a moment. Once I see everyone is in the space, we will jump into it. All right. Okay. All right. I think we're going to get started. So, hi, everyone. Welcome to this webinar, which we're calling Learn with Producer Hub, SDC edition. My name is Dani Barlow. My pronouns are she, her, and I'm the programming director and co-lead of Producer Hub. I'm really thrilled to have you with us today. A couple of things to mention before we dive into the topic at hand. First, for those who don't know Producer Hub, our mission is to provide independent producers and artists at every level with community, mentorship, education, and resources to create work, realize their full potential, and make lasting contributions to the performing arts field. And today we're doing that by providing an in-depth conversation with our guest from SDC to talk more about the development and tier contracts at SDC. As we know, some of you might utilize them or may need to use them in your work in the near future. So really excited to jump into that conversation shortly. Additionally, I just want to take a moment and offer a land acknowledgement on behalf of the group and share that we are hosting this Zoom from the traditional lands of the Munsee, Lenape, and Mohican peoples, which is currently known as Manhattan, New York City. I also want to acknowledge that this Zoom, which we are using for this webinar, is headquartered in what is now called San Jose, California, on the traditional lands of the Ohlone and Tamian peoples, which feels important to acknowledge because this technology does require land to reside in order for us to utilize it. And we'd encourage you to learn about the lands that you're currently residing if you don't already know. And as we're an arts organization, we'd encourage you to learn more about the Indigenous artists and their work that are in your community. I'd also like to thank Alana and Liana from All Hands in Motion, who are providing ASL interpretation today. Finally, I just would like to talk through how this webinar will run. In a minute, I'll invite our guest to the screen and we'll spend about 45 minutes chatting interview style to hear more about SDC and the agreements we're covering today. As this is happening, please feel free to drop any questions you might have in the Q&A section of the Zoom interface. And once we're done with the interview portion, I'll read out some of the questions for our guests to answer. So please be sure to use the Q&A function at the bottom of the screen to share your questions. And if you have any technical needs, you can also drop them in the Q&A as well, and we'll answer them as we are able. All right. So with all of that introduction, I would like to introduce Kristy Cummings, the Director of Contract Affairs at Stage Directors and Choreographers Society, which you can surmise by the title is the Union for Stage Directors and Choreographers, to the screen. Thank you so much for joining us, Kristy, and welcome.
Hi, thanks so much for having me.
Yeah. Oh, are you here?
I am here. Sorry.
Oh,
okay, I think I'm good now.
Great, perfect. So I'm really happy to be here talking about SDC contracts. As some may know, my former place of employment was associated with SDC, and I learned a ton. And so I'm really excited to be able to do this today to share some of that knowledge and some of the things that I learned while being there to help other folks as they're producing their work. So I'd love to jump in and just go really high level, very basic. Can you just talk a little bit about SDC, its purpose, what it covers, and maybe what it doesn't cover, and like who it serves? Can you just give us like an overview of SDC?
Sure. So SDC is the Stage Directors and Choreographers Society. We're a national theatrical labor union, and we represent professional stage directors and choreographers across the United States. Sometimes also abroad if something has originated in the United States, but we can get into more of that later. But our mission is to unite, empower, and protect our members working in theater and live performance. And so that's like our purpose, I guess, as well. We cover, the union sets minimum terms and conditions for engaging SDC members, or in certain jurisdictions when you're engaging any director or choreographer. And some of those terms include minimum compensation, health and pension contributions, termination protections, dispute resolution provisions, property rights protections, which is like one of the bedrocks across all of our agreements. And now also in the last 10 years, our electronic capture provisions have really expanded and become more robust. And so that's like in a nutshell, some of the things our agreements cover and what we, set out to protect for our members. And our members include, it is directors and choreographers, and more recently has expanded to include specifically fight choreographers and associate directors and choreographers. And we also cover other specialty choreographers at the moment as well. But we also serve, our membership also does serve, we have 2 levels of membership, which we can get into if that's applicable. There's the contract filing membership, which is the full membership. But we also have an associate membership, and that's for either sometimes directors and choreographers who are just starting out, and so they're professionally affiliated with us, but they don't have the obligation slash benefit, I like to say, of filing SDC contracts, but they do get some of the access to come to meetings and get our, our monthly e-news, so they're in the loop on what's going on for directors and choreographers in the industry. And so we also foster the associate membership. Also fosters our relationship with academia. And so we're, some associate members are, full-time professors in universities. And so we provide some services and benefits to those folks as well. So I think that's high level, unless I missed something, Dani, but I think
No,
okay.
that's great. Well, I guess I would, just to make sure, the kind of like who you cover and who you don't, this is directors and stage directors and choreographers in like anything that is live perform, or like how would you articulate like anything that is live performance, or yeah.
Sure, we say live theater or live performance. If it's live and on stage, then
Great.
we believe we will cover you as a member. So there's 2 sort of facets, right? Like, so if you're a full SDC member, the contract filing membership, anytime you are engaged to direct or choreograph on a live stage or for live performances, you are supposed to file a contract. So we do like to say there's no such thing as a non-SDC theater. It becomes an SDC theater by the virtue of them hiring an SDC member. But then we also have, formal agreements with folks like on Broadway. Anyone hired on a Broadway production as a director choreographer, whether they're a member or not, will be engaged on an SDC contract because we have negotiated that jurisdiction. So there's a few arenas like that where non-members may be engaged and then may be on the path to joining, because there's some certain, provisions about that in each of our formal jurisdictions.
Great.
Yeah.
Great. Thank you so much. Okay, so I'm going to start from like the beginning, like through the lens of a producer. It's like I'm working on a show, I'm a producer, and I want to hire a director or choreographer. They might be a member, they might not. Like I'm not even sure. Like there's this person I want them to direct a show that I am producing. Where would you start, and like how do you figure out like what agreement they should even be on? And I'm thinking kind of like specifically through the lens, which is like not necessarily like a covered theater, right? Like it's not a Broadway show, right? It's something that you're like, I'm not exactly sure where I start.
Sure.
Yeah.
So I think like we have some resources on our website that can kind of guide you. They need to be updated, I think, but they can guide you through some questions to figure out what contract you're supposed to be on. But I think I would first say, if the person you're interested in hiring, to ask them if they're an SDC member, because the sooner you know this, the better, and the more time we have to navigate the contract requirements, it's always helpful. We will let you know if someone's a member. So if you call us and say, hey, I want to work with so-and-so, do I need to engage with SDC? We will tell you, yes, we can share that information. Like, oh, yes, that's a member. And then we would go through our list of questions with you. Because again, if they're a full member, then you would have to file an SDC contract for, if you're hiring them to direct or choreograph a production. And so, I think my best advice is to just call the contract affairs department at SDC. There's 4 of us in that department that do the contracts across the country. And we have a lot of different types of contracts, and sometimes it is confusing. It's like, well, it's a workshop production. So is this development or is this on your tier contract? Like, what am I supposed to do? So we'll have a conversation with you and ask some particulars. Like there's some criteria for development where like you can't have press come, right? Or you're not supposed to charge tickets. But sometimes it's a benefit. So we let you charge a ticket because it's a donation. So it can be very bespoke. And so I do encourage like to call us, and we'll ask you some questions about, are you not for profit? Are you commercial? What size house are you producing in? What is the scope of work? And then we can sort of direct you to the contract that's appropriate. And again, like the tier or developmental, if you're not party to a formal agreement, those are probably the two you would most likely be put on. There is a regional commercial contract. If you're like a commercial producer who's going to produce outside of New York City in a larger theater above 100 seats, then there's some restrictions on when you can use the tier. But yeah, I think that's the best advice, is to call us, because it depends on the project and it can change from project to project, or it could change if we know this theater, if all the actors are on like a specific contract, it might trigger a contract of ours that is different than if they were using non-equity actors. So yeah, to call us is the best advice.
Yeah, and that actually leads me to like two different questions. One is, I'll ask them separately, but the first one is, so if, like, let's say I'm producing something, again, it's like not in a covered theater, I'm not sure if it's development, I don't know what it is, but I ask the director if they're a member and they say no, they're not. Is there anything else I should be thinking about that might trigger the need for an SDC contract anyway? Or, like, is there anything I should think about before I, like, not get in trouble, but before I'm like, oh, actually I should have put them on a contract even if they aren't a member yet? Like, do they, like, is there anything that should be thought about in that?
I think probably the clearest answer is, if you're producing in New York City and you're in a theater of more than 100 seats, you should call us, because often that does trigger requirements under the Off-Broadway agreement, whether they're a member or not. Also, sometimes if it's a non-member and a non-Off-Broadway league member, a contract might not be required, but then if that production wants to be eligible for Lortel Awards, for instance, then a contract is required. So based on, that's probably the trickiest. There's a lot of rules in our New York City. So like the tier, no one can use a tier contract if it's more than 99 seats in New York City, because we have established jurisdiction with the Off-Broadway League. So we've agreed that we won't infringe on that, right? Like if you're going to be in 100 to 499 seats, then you're on some version of the Off-Broadway agreement. If you're engaging an SDC member, or you're going to be eligible for certain awards, or you're joining the league. So there's a couple of different ways you might end up on one. Even if you're not hiring a member or you're not affiliated, you could still land on an SDC contract. So
great. And then the second question that I had was, you mentioned a little bit ago about how, if actors are on a certain agreement, that might trigger this agreement over here. I think I know the answer, but I'll say it out loud, which is, do equity and SDC agreements like line up like this? Like, like all of the SDC agreements and the equity agreements for this size house or this type of thing, do they pair together, or is it just like you have to understand which agreement for SDC the director is on, and it might not be the same type of agreement that, like, the equity actors might be on?
Sure. For our formal jurisdictions, I think for the most part, they line up. So like the Broadway agreement with SDC is the production contract with, Actors Equity. Or like the League of Resident Theaters, the LORT agreement, which is, it's a bargaining unit of 81 theaters across the country. Those are the same 81 theaters with SDC on our LORT contract as equity on theirs. So, and the same with Off-Broadway, we have the same defined jurisdiction, but that's one of ones, like our SDC contract says, if you're engaging actors under the equity Off-Broadway agreement, our contract's required. So, so that's one that's really strictly linked as well. When you get out into the rest of the country, like you could be on a tier contract with us, and equity, I believe, they call them letters of agreement. Like, so they may be on an LOA that references a different agreement with them. So when it becomes like a singular employer situation, it may not line up exactly.
Yeah. Great. Okay, so just a reminder, folks, I see a couple of people are putting questions in the Q&A. You're always welcome to do that as we are having this first part of the conversation. But now I'd love to just talk a little bit about, what we're specifically here to talk about, which is developmental and tier contracts. I'm wondering if you could just talk a little bit, just like on a high level, the high level like difference between the two of them.
Sure. So the development contract is intended for developmental activity. So a reading, a workshop, not a fully produced production, even if it's on a small scale. So it can include a presentation at the end of the process. But our basic development contract has 3 criteria. It says no box office, no press, and no more than 3 weeks of rehearsal. As I mentioned at the beginning, there can sometimes be exceptions. We put those criteria in so that if you don't meet one of those, you will call us to figure out what you're supposed to do, because there are situations where it is really a reading series. Everyone has a script in hand, but you're going to charge $5, right? Or it's a $10 donation to the organization to come to the reading series. And those often, you need the exception from us, but we will permit those to still be on the development contract because it is truly a reading. The tier contract, on the other hand, is for a production. And even a small scale, so even our 99-seat houses, $10 tickets, 5 performances, that will be on a tier contract because it is a fully produced production. And the tier contract is required. So by the members' work rules. So if you're hiring a member to do a production, and you're not part of another formal, bargaining unit, you would likely be put on the tier contract, or have to use the tier contract to engage them. The development, on the other hand, our members' work rules. Typically, our members always request a development contract. If it's a commercial project, they are required to be on one. If it is a not-for-profit project, we encourage them to file one because they get health and pension, their property rights are protected, all those things, but they could choose for a very small scale, not-for-profit, project to not request one. That's the current rules. They could always change, but for commercial, they are required to file for that activity. So I think, is that anything else? Am I missing anything? Or is that
No. I think that,
okay.
yeah, I think that's great. I'm wondering if you can, I guess it's just the kind of follow-up to that question is there anything else to be thinking about in terms of just things that people should be looking out for as they're trying to figure out oh, this is I guess, let me pause. Developmental, can it hold kind of any size or scale of workshop? So it's development at any scale. It could be development of 2 people for a presentation for 5 people, or for a Broadway developmental project. They all fall under development.
They all fall under development. So there's some cases. So our Broadway agreement, off-Broadway, our formal agreements have development provisions. So they have their own rules about what is due for development work by those producers. The one that I walked through with the criteria, that's for folks who are not party to a formal agreement. They would use what we call our promulgated development contract. I think a key difference probably between the development and tier, which I didn't talk about, is the development, it's a negotiable fee, which is partly because it's it could be a 1-day reading, or it could be a 4-week workshop with a presentation at the end. And so we leave the fee, we don't set a minimum fee there, but there's benefits for each day of work with actors. So it's based on how many days you're working is that one financial piece that's set. The tier, on the other hand, sets minimum fees for each level. There's 7 levels of tiers, and it's based on a gross potential box office calculation. So we look at your seating capacity, your top ticket price, and your total number of performances. And that puts you in one of 7 tiers. And then there's a fee, a health contribution, and a pension contribution as the financial components. And that does not, rehearsal period is not factored into that. So you could rehearse for 2 weeks, or you could be rehearsing for 6 weeks. It's based on the potential income of the project, is the calculation that we use.
Great. And just another question around that too is, so again, there's a handful of questions that people might be asking themselves. What agreement is it on? Is my director need to be covered? All of that kind of stuff. How, obviously I imagine it's as soon as possible, but how much time does it take between making a call to the office, or submitting that this person needs to go on an agreement, or you're just trying to figure out if they do, and when the show what is the ideal amount of time to if
Sure.
you needed to put someone on an agreement, a contract?
I mean, it can happen very quickly because at this level, so like the tier in development in particular, if you called us and said, and we are like, oh yes, this is a tier contract, we could walk through the calculation with you, confirm what that is. It's available for download on our website. We don't require bonds at that point. So you can just download the contract, fill it out. And, if you haven't, obviously make an offer to your director or choreographer, but if you're already at the contracting stage, like you can just send that. And as soon as it's signed, it comes back to us for filing. So, I mean, that can all happen very quickly once you get your questions answered. Contracts are due by first rehearsal. And so I guess backing out from there, however long you might need to settle on the terms and get everyone to sign the contract, you should be thinking a couple weeks ahead, I think. But sometimes I think what can take longer is on the tier contract. Say you come to us, we looked at the calculations and you're like a tier 6, right? But it's your first time hiring SDC. You're like, this is way too much for my budget. There's like a process by which you can request a concession that we'll consider and may, provide some relief in the fee compensation. Because our philosophy is we would like to establish a relationship with you and cultivate that relationship as opposed to being like, oh, you can't afford us, never mind, you can't hire our members. Obviously, we don't want to lower standards so much that people are like, why am I in a union if you're just going to give it all away? So there is like a happy medium between that where we try to find what is tenable for everyone and what is still fair and equitable. But to start our relationship with you and allow our member to do the job. So if that happens, that could take a little longer because we have an internal process where we review the information, you send a request in writing, we look at all the particulars and then, get back to you. We can turn those around in a couple of days, but sometimes it could take a little longer. So that's the only thing that might, in these jurisdictions, sort of, elongate the process. And then I guess if you're dealing with an agent, that could also take more time. So,
right. Yeah. Well, and actually that leads me to another question, which is like, so again, I'm a producer, I'm engaging with a director or a choreographer. Let's use a choreographer this time. I'm engaging with a choreographer. And you're talking about kind of like there's different tiers, different levels. The first thing I'm doing is engaging with you, SDC. And then am I presenting something to the director? Like when does the director find its way into the SDC of it all? Is it like, I've talked to SDC. This is the agreement we're going to put you on. These are the particulars. I'm presenting it to you. Or do I, the producer and the director, talk and figure something out, and then we come to SDC and say, this is what we want to do? Like, which direction does it go?
I think it happens both ways. So some producers will call us to be like, okay, what are the minimums? And then they know like the floor they have to hit, and then they'll go and make their offer and negotiate with the director. We also have sometimes directors and producers being like, we're ready to do this project. We've agreed on this fee. Does it meet the requirements of what SDC contract we have to be on? So it does happen both ways. So I guess it just depends on your relationship and what the process is. Some producers get the nuts and bolts from us and then go to the director or choreographer. And sometimes they come to us together. Sometimes the member is the one who comes to us and is like, I really want to do this project. And they only have $2,000 total. Like, what am I allowed to do? And so we'll work with the member and then loop in the producer. So it sort of happens in a lot of directions. Because our members are always, all of our contracts include our members can negotiate, they're within their right to negotiate above the minimums, like the minimum is the floor. So we will say, this is the minimum, this is what we can enforce, but like you need to obviously talk to the director or choreographer directly as well. So.
Great.
Yeah.
Great. And you mentioned this at the beginning a little bit, but can you talk a little bit about I imagine it's for both of these agreements, but you can let me know if that's true, that there's obviously going to be the minimum fees, but what are the other things that producers are going to have to be considering in terms of monetary or otherwise that they will need to provide for anyone they put on a contract through SDC in these specific contracts?
Sure. So, I think I briefly said, so property rights are a key component of our agreements. So the direction and the choreography that our members create in the rehearsal room is theirs. Producers, by signing the contract, have a perpetual and irrevocable right to license and use that work as long as they're paying them properly. So by entering the contract, you're licensing their work essentially for that first initial run. But then should you revive that show or take it on tour or transfer it somewhere, you can only continue to use their work provided you're paying them under the applicable SDC contract. Because it is theirs. They have the right to copyright their work. And so we always have to maintain that they have the ownership, but you have a perpetual license by virtue of being the producer and signing that contract. So that's something to keep in mind, that if you are doing a future show, hopefully everything was like lovely and the whole team is going on to the next phase. But if they're not, then there's some, ramifications of what you're allowed to do, what you might have to pay for, what you might have to do to tie up those loose ends. Connected to that is the right of first refusal. Most of our contracts have a version of this. The development contract actually does not. And that's because our members, it was producers and members both, were like, if we encumber the production too early in the process, producers may only hire like the really established directors and choreographers. Like they won't take a chance on an unknown because they know they're going to be tied to this person forever or have to pay them. And so actually our members were like, we want to be considered, and we don't want to like make it too high a bar that they're not going to give a first time an early career director or choreographer a chance. So that's not in there, but can be negotiated as an above minimum term that then the union would enforce. So if there are additional terms in a rider to a contract, we do enforce those on the member's behalf. But the right of first refusal is that, like, if there is a subsequent production that, if you've signed the original contract, that you will be offered the first option to direct that subsequent production. And that's obviously, if there is a subsequent production, the philosophy is, the first one was successful to some degree, and you're doing it again, and the director and choreographer had a hand in making that success, and they should have the first right to do the next job. And if for some reason they're not afforded that, some of our contracts, like the tier, has like you have to pay them $2,000 or 50% of the subsequent fee of the buyout. And then some of our other contracts are not that explicit, so there has to be like a settlement made or full payment of the next fee to them. So that's an obligation as a producer that you're taking on when you sign one of our tier contract. Again, that's not outright minimum in the development contract. Some of the other things that, one that's beneficial to both sides is we always have a dispute resolution provision. So if there is a dispute over a term in the contract, or, if there's a dispute over a payment, whether it's required or not, we always try to solve things amicably. The contracts affairs staff will be in touch, and we try to work through any issues that arise. But then usually there is some sort of either a grievance and arbitration process, or on the tier and development, it goes right to arbitration if you can't solve it amicably beforehand. But the protection there is that arbitration is usually a more efficient and cost-friendly option to resolving a large dispute than like everyone just suing each other in court to get their way. So that is like a provision that everyone agrees to abide by, so that we have the channel within the agreement to resolve any disputes that come up. But we're usually we're pretty, I like to say we have a good track record with producers. We're usually able to work through most issues or solve them or come to some sort of agreement if there is some, interpretation question or something like that. So it's always best we get on the phone with people first and, before any formal proceeding begins under an arbitration clause. So I'm trying to think what else. So health and pension is a huge part of all of our contracts too. We have a joint, it's the SDC League Health and Pension Fund. So it's jointly administered by the Broadway League and SDC. It's run by a board of trustees, which I am actually one of the union trustees on that board as well. And so the benefits are all provided from the health and pension funds, but the union negotiates what contributions will be due under each contract. And so that is how our members, if they reach the eligibility threshold, will qualify for health insurance, will vest in our pension plan. And so that's really important to folks as well. And then, just some other, there's billing is required. So some is really specific that's like everyone has to have a line by themselves and has to be on, in the program and on any house board. Some is just like you have to be billed. So a lot of times like size and placement is negotiated like on case by case basis. But
Great.
I think those are some of the key ones.
Great.
Yeah.
Great. And following that a little bit, is there anything that producers, because ultimately the agreement is between the producer and the director or choreographer.
Mm-hmm.
And so is there anything, and like obviously like you can negotiate above minimum terms, things like that. Is there anything that like, other than like something illegal, is there anything that like a producer can't put into an agreement with a director or choreographer that like I don't know, I'm just asking, I don't actually know if there's like, it's not a leading question, I'm just curious.
Yeah, no, sometimes we review every contract that comes in and every writer, and sometimes there's things we send like comment letters on and say, we don't accept this portion of your writer. One of the most common ones is like, it's called no injunctive relief. And so the producers will put in a provision that says like, if there's a dispute, the director can't like shut down the show, right? And while that typically is not how we resolve disputes, it's also not in the contract that is like, that's relief provided under the agreement, right? Like it doesn't let the producer do that under our agreement. So we say, that's not in the agreement. So we can't all agree that that's out of bounds as an option. Again, that is not, in my 13 years in SDC, I have never shut down a show as a way to, resolve a dispute. But so it's sort of just trying to be like, this is what we're allowed to do in the agreement. This sort of goes beyond that. And so we can't agree to that at this time. So there's some things like that. Sometimes there'll be some, once in a while, someone will like sign away their property rights and we're like, they're actually not allowed to do that. It's a minimum term. So like one of the members' work rules is that they can't agree to substandard terms. So they're not allowed to accept anything below SDC minimum unless there's been a concession process or a board approved concession that's happened. So sometimes things will come in a writer and they're like short on compensation, or sometimes it's a math calculation error. Sometimes it's like intentional. And so we'll have to like adjust those and do addendums and things like that. But
great.
Yeah.
Great. Okay, well, and that's helpful to know. I mean, obviously, I shouldn't be surprised, but it's like you do then see like once the negotiation has happened, you do see everything before it moves on. Yeah.
Right. And like the tier contract and development, we do sign the union because they're promulgated and we don't have a formal relationship with the producer. Like we sign off on the bottom and send you it back. And once you get that sent back in the via email, you're like, oh, okay, everything's processed and good. There was no questions. Or you'll get, an addendum and it's like, this was substandard. So you have to like, this additional is due, please sign this addendum. I guess one other thing, and this could get us in the weeds, but I should say we do often have to comment on the fact that our members are employees. They're union members. So when they're engaged on a union contract, our position is they're employees. And so often there will be language in a rider that, they're independent contractors. And so we do comment on that. I will say like that is a practice of payment. Some of our folks are incorporated. So like how they're paid is a piece of that, but like our position is always they're entitled to all benefits as an employee. So like if they got hurt working on your production, they would be entitled to workers' comp, things like that. So that is something that is a little confusing, I think, about directors and choreographers at times. I think it's getting clearer, but I thought that might be an important thing to say. 'Cause you may get a letter being like, our position, just so you know, is that they're an employee. So like if anything would come up, like we would take that position formally. Yeah.
Great. Wonderful. There were a couple questions that came in before the session that I'm going to ask that I think are like helpful to the group, and then I do see we have some questions in the Q&A, so then I'll ask those as well. This has been super helpful. Thanks for like getting in the weeds. I'm hoping this is helpful to other people too, but these are the kind of things that you need to know when you're doing this, the like not so sexy stuff, but really important. There's a question that says, like, is the use by SDC of the term developmental based on the same rules as the contracts that are called workshops by equity. Are those the same? I imagine they're not exactly the same terms, but like, I guess if someone found out that they were going to put someone on a developmental contract, does that immediately trigger something specific at equity, or would you just recommend they have two different conversations about that?
Yeah, sometimes. I mean, I do think so. Like, I know equity, they have obviously they're 29-hour readings. They have work sessions now. They used to have like lab and workshop contracts. I don't know how much those still persist, but those are all considered developmental by us. A lot of, I would always suggest like talking to equity separately too, to make sure you're doing what they need you to do.
Yep.
Our developmental contracts in most of our agreements, it's based on days. So a lot of times like in LORT or off Broadway, it's like 14 days or less is this structure. And once you're 15 days or more, there's a different structure, which is more of like what we call workshop informally, but it's sort of based on the length of time. Our Broadway agreement does specifically separate, like, this is what a 29-hour reading is. Anything else is like a work session, and that's a different, kind of structure for benefits and such. So yeah, I would always talk to equity, but I think for the most part, like our development provisions cover what is equivalent in equity as like readings, workshops, etc. Yeah.
Great. And then I think you kind of answered this question, but I'm gonna ask it just to further clarify. But so it says, someone says, equity has a mini contract for productions that are mounted in theaters 99 seats or less. Does SDC have such accommodations for small productions in these small theaters? That would be tier.
That would be our tier contract. So,
Great.
and so in New York City, the tier is for 99 seats or less, for commercial and not for profit. I guess I should ask, is everyone here commercial, or could it be either? I don't want to keep talking about not-for-profits if it's mostly commercial producers.
No, I think it's going to run the spectrum. So
Okay.
I think speaking in both terms is great.
Great. So outside of New York City, not-for-profits can use tier contracts, pretty much in any size theater. Commercial producers can still only use tier contracts for 99 seats or less. And then we have a regional commercial, which is a little more equivalent to off-Broadway. And so that's just the distinction. But in New York City, yes, the 99 seat, a 99 seat show or a festival, often festivals, like things of that nature, those are all on the tier contract.
Great. Wonderful. And I'm wondering, this was just a question that I had because I was curious, but if you are a producer and you're also directing the show, is there something that has to be kept in mind, or does that so I'm an SDC member. I also now want to produce my own work. And so I'm the producer on record and I am the director. So I'm curious if there is something about how you approach that conversation or what my responsibility is when I'm engaging with SDC.
Sure. What we tell our members is that if they're the sole producer, like the only person producing, the only person who can sign a contract, then we actually can't take a contract and they're relieved of their contract filing obligations for their project. Now that's on like a solo, that's as long as it's not on any formal, it's not like a Broadway show, because then there's certain rules about Broadway, and some other jurisdictions. But like on an independent project that's not formally affiliated, if you are the sole producer, we can't accept a contract, because otherwise you're signing both sides. And then we're like, we can't protect you from you. So if like you don't pay yourself, we have to go after you for, arbitrate against you. Essentially they're relieved of the obligation. Oftentimes they are a producer, but they might be part of an LLC or not-for-profit company where they might be the lead producer, but like the entity can sign the employer side of the contract. So someone else as part of that entity is authorized to sign on behalf of the producing entity, and then they can be engaged on an SDC contract. And a lot of our members like to do that because they want to get their health and pension and their property rights and all those protections, especially if they're not, the sole producer. So some people, like in a not-for-profit situation, a small not-for-profit, like even if they're both producing, like the managing director will sign on behalf of the employer side, and the director as artistic director will sign on the member side, or like an LLC, whoever, someone else might be authorized, like a general manager or a co-producer will be the signer. So as long as the same name is not on both sides of the contract, then we're okay.
Great.
Yeah.
Great. And one of the other questions that I had that feeds into actually one of the questions that someone who is watching has asked, so it's good timing, is this scenario that I came up with, which is like I'm doing a show, like a site specific show. It's in a restaurant that I've turned into a theater, and I want to engage an SDC director. Um, like so a non basically like a non-traditional venue, right? Like
Mm.
where do you start with something like that? Would that just be similar because it's live performance to just is it so yeah, I'm curious like for site specific work like where you'd start.
Sure. I mean, we consider that live and theatrical, and so that our members should be filing. We will go down like through a process of like, well, what contract is that, right? Like, because the tier again, like looks at that gross potential box office. So often we can still use that because there'll be like a number of attendees each night and what the highest ticket price and how many times you're performing. So like sometimes that will still just apply. Other times if it's like kind of more complicated than that, or like I just actually did a contract like it was like a living history walking tour that someone directed. And we're like, how do we even put that? So we have a special contract. So that is a contract that is for like unique circumstances. And so it's a little more flexible. You need permission to use that contract. So you would reach out to me and say, this is the situation. But it doesn't use that gross potential box office, and is a little more flexible because some people use them to like direct industrials. These like some immersive productions are on that just because it doesn't fit into the criteria for the tier for various reasons. So yeah, so I mean, we would take the position the member should be filing. And so like, then we would say, let's have a conversation about where we put this in our universe. Yeah.
Great. Wonderful. Okay, another question. Do producers pay for health and pension or is that baked into the fees?
Those are in addition, and producers do pay them. So so yes, the health and pension are above and beyond. So even if pension on a lot of our contracts is a percentage, but it's calculated on the fee, but it's in addition to the fee. It's not like withheld from the fee. There are the other financial component that the member technically pay. There's working dues on every contract. So on some contracts like the tier and development, they'll be billed directly. So you pay the member in full, and then they're billed by the union for their working dues. But on formal contracts like off-Broadway, Lord, like those more formal agreements, the producer withholds those working dues and sends them to SDC on their behalf. But the benefits are always above and beyond the fee.
Great.
Yeah.
Great. Okay, there was a question that says, so I'm not just speaking about development. It says, so a nonprofit can do up to 3 weeks of development and the development contract is not mandated. Is that true?
So if it's purely developmental, currently our members' work rules permit them to choose not to file an SDC contract for development work at a not-for-profit. So we do have some smaller not-for-profits across the country who I think people, members do choose not to file. Again, if they're affiliated, so like Allure Theaters, they're all not-for-profits, they are required to file for SDC members for development work. So there's some, depending on the jurisdiction, it may be required, but under that promulgated contract, if you're not otherwise affiliated with a bargaining unit, it is at the member's choice. Now, a member is within their right to say, I don't want to do this unless I'm on an SDC contract because they want the SDC benefits and things like that. So they are within their right to do that. But if they're like, hey, I don't need a contract, or, don't choose to file for this because of certain reasons, like we're not going to come after you for a contract, like from the union.
Great.
So.
Great. Wonderful. Okay. I want to try to phrase this one correctly, but there was a question about why 16 performance show contracts, like why they can't be eligible for awards like the OBs, the Lortels, etc., or 99 seat and under shows. And I'm wondering if that is a question for SDC, like who I am just curious in terms of like who sets the rules for size of venue, things like that for these
Yeah, for all the awards, like that's all you'd have to reach out to those award places like the Lortel Foundation or the OBs of like how they set their criteria. So yeah, we don't determine that. We do like obviously any awards, if they need verification, like we'll confirm that contracts have been filed, if that's part of the process, but we don't determine those criteria. I mean, and again, our SDC Foundation is separate from the union. The SDC Foundation does have some rules about some of their awards and what has to be on a contract. And I don't know those in and out, and Dani might know them better, but I do believe like some of our, I think like our Callaway Awards, I think can be on a tier contract. I don't think that there's some different levels of things, but those are all set by the organizations that give those awards out, not by the union.
Great, great. Thank you. And then there is a question about if someone's an associate member, how does that affect the theater, if at all? And I think that that actually makes me ask a kind of follow-up question to that. So associate membership, and then also what triggers membership. So
Sure.
if you're a producer engaging with a director and they're like, oh, I'm not a member yet, but like, is there something that might require them to, or what might trigger that?
Sure. So an associate member doesn't have a contract filing obligation. So if you're a theater or a producer who would otherwise file a tier contract, if someone's an associate member, there's no obligation for the theater to put an SDC contract together. And we actually can't take a tier contract from an associate member. Those are for full members only. There are some situations in our formal agreements where you have it's called union security. So if we have 100% union security, it means any director or choreographer you hire has to be on an SDC contract that meets minimum terms of our collectively bargained agreement. And so in that case, non-members, associate members may be put on SDC contracts. And then, as I mentioned previously, that would start their path to joining. So some of our agreements, like our Broadway contract, the union security, it's full union security. So everyone's on a contract. And if you're working more than 30 days, the agreement indicates that you then join SDC. LORT's a little different, right? It's usually your second contract. So your first one, you'll get an invitation from us. And then the second one, you'll be like, the agreement now indicates you need to join the union. It's second or third. There's so many rules. It's the second or third, depending on the category in LORT. But as an associate member, in the tier or promulgated development universe, there's no contract filing obligations. One thing they get as a member, just so you know, associate members do have access to the contract department. So they can say, hey, could you look over my non-SDC agreement and see if there's any red flags? We're not lawyers, we're not agents, but we can say, oh, compared to the tier contract, you have no property rights in here. If that's something of interest to you, you may want to negotiate that. So we don't have direct relationship with the employers on those, but we can offer advice that way to our associate members. So.
Great, thank you. We have run through a ton of questions, which is great. I'm going to ask one more question and just say if there's anyone else who has a question that they'd like to ask, please feel free to drop it in the Q&A before we get close to the end of our time here. I feel like I've run through a bunch of my questions, and I think that the only real bigger question I have for you, Kristy, is there anything else that producers should know when engaging with SDC? I feel like you've said call us, we'll talk to you. Are there certain things that you'd like to, if you have this audience of producers, is there anything you'd like to say to them in this moment when engaging with SDC?
Yeah, I think that's the main is try to plan ahead. We know that can't always happen. Sometimes things come together, your theater all of a sudden opens up, right? And you're we're going to rehearsals tomorrow. So we totally get that and we'll work with you. But as much as you can plan ahead, that avoids if there are any pitfalls, we have time to solve them. Our website has most of our contracts are available on the website. So that's a great resource to you if you're curious about what your obligations might be once you know what contract is applicable. And again, yeah, if you have any questions, and I don't know, Dani, if there's follow-up, I'm happy to have my email go out to these folks. There's also our general contracts at sdcweb.org. You can always send questions there, and it'll be routed to the appropriate person to be answered. Oh, I think something really, it's so basic, but something super important is file the contract, right? So you've done all the work, you've found out what contract it is, you've negotiated with the director, choreographer, everyone signed it. You'd be surprised how many times the contracts don't make it back to us. And technically the employer is always supposed to file a copy and the member's always supposed to file a copy. So it's hopefully we get 2 copies, but it's a fail safe that hopefully we'll get one. And sometimes we don't get one, and we won't. And in the tier development world, we don't have the same tracking systems in place. So for Broadway, LORT, off Broadway, we get a production schedule report, or we, follow the theatrical index for Broadway. We know what shows are coming. So we know when we're supposed to reach out and say, hey, we don't have this contract. But when we're looking at like tier theaters across the country, we can't possibly track everyone's season so closely. So we really depend on the member and the employer to file their contracts so that we can, you know, process them, apply the benefits you've paid. Because without a contract, the benefits don't get applied and don't accrue to the member. Like, we need all that information. So as soon as you sign a contract and the member signs off, like, you can email to file. You just can email us a copy at that contracts@sdcweb.org, and it'll get processed. So yeah, that would be super helpful. And tell your producer friends to file their contracts.
Great. Amazing. Okay. Is there anything else you'd like to share? I don't see that we have any other questions. So unless there's anything else you'd like to say to take us out, I'll just close out this session.
I mean, yeah, I mean, just like we do try to be like super open, and we like to have an open line of communication with producers. It's interesting. Often we only have one member on a show. I mean, if it's a musical too, and now with associate directors and choreographers, we might have 4 or 5, but it's sort of a much different position than some of the other unions who may have like a cast of 25 in your show. And so sometimes if there's particular needs or nuance that you have questions about or need addressed in your particular situation, like, we can't promise we can always accommodate everything, but we can often have a little more flexibility because we are working with a smaller group of people on your show. And so, yeah, I just would encourage you to call us with questions, because it's always easier to solve something before, rather than like in the midst of rehearsal when we find out, oh, this isn't compliant and now we have to undo it and your budget, you know, and it gets more complicated. So yeah, I think that might
Great.
be.
Wonderful. All right. Well, thank you so much, Kristy.
Yeah, thanks for having me.
Thank you. Yes, thank you. And thank you to everyone who is watching this webinar either right now or in the future. We do plan to share this recording of this panel publicly so other people can watch it back and get the information that they might need. Also, we're like thrilled to be ramping up our programming at Producer Hub. This is like the first of hopefully many. We plan to have another session with Actors Equity Association coming up in November, kind of similarly to this, diving into the 29-hour reading code and the showcase code. So you can sign up to our newsletter on our website or keep an eye on our socials for that. We plan to announce that hopefully later today. And also, if you're interested in hearing about other topics related to independent producing, feel free to write us at info@producerhub.org. As we start to build out our programming, it's going to be great to hear what topics you're interested in. And finally, feel free to follow us on social media, on Instagram @producerhub.org and LinkedIn. More programming will be announced there. And again, same thing with our mailing list on our website, producerhub.org. All right, that's what I got. Thank you so much for joining us, and see you later. Bye, everyone.